Oh, welcome to the Legal Services October monthly webinar. We're very excited to be here. I'm going to introduce our speaker in just a few seconds, but before I did, I wanted to cover a couple of housekeeping matters. Number one, again, this is Legal Services Alabama's monthly October webinar. Presented by Legal Services. For those of you who don't know, Legal Services is the not-for-profit law firm that provides legal services to low-income people all over the state. Alabama has 900,000 people, maybe up to 1 million, depending on which estimate you use, who live below the poverty line, and 1.7 million who live below 200% of poverty, which is still basically living paycheck to paycheck. Legal Services helps all those people, but if you are a private attorney, we are hoping that you will consider also helping those people. Contact your local volunteer lawyer program. You can do that by going to the Alabama State Bar's website and signing up to do that, and they will get you to the correct volunteer lawyer program. A couple of things about today's webinar. If you signed up and provided your Alabama Bar ID, you are good. You will get credit. If you watch the whole thing, the computer will know it and it'll send me an email. So there's no need to send me the email afterwards asking how to get credit. You've signed up, you watch, you get the credit, nothing else for you to do. If you didn't put your state bar number on there, you should go ahead and follow up and send that to me so I can give it to the state bar. That's the one catch. If when you filled your registration form out, if you didn't happen to fill that part out, or if you didn't put your correct name in, that is the list we go by. So, go ahead and get that fixed and we will give you credit. And the last thing I will mention before turning this over to Mr. Martin is that as we go along today, I assume Mr. Martin wants questions, and you will be able to ask questions. If you look at the side of your screen, there should be a bar, and down at the bottom there'll be one for chat, and that's just for talking. But if you have questions about the law or what he's talking about, go ahead and type those out, and at the appropriate time, I will raise my hand and let Mr. Martin know that there's a question, and you'll get that answered. And rest assured, if you ask a question, the computer will not lose it. Sometimes I just, I don't want to interrupt the flow of the conversation, but if you have questions, make sure to ask them, and we'll make sure to get those answered. With that being said, I'm going to turn it over. It's noon now, so I'm going to turn it over to Mr. Martin. I will say I've sent his biography was attached to the registration email, so I'm not going to cover that. But I will say, as a personal story, the reason I met Mr. Martin was 4 or 5 years ago, maybe 3. I actually had a case that I did not know was an ERISA case, and so I can tell you from personal experience that this is one of those fields of law. You're here, so you're safe, but if you weren't here, it can be very dangerous not to know what you're doing, especially if you get involved in certain employer-provided health plans and stuff like that. And thankfully, with his advice, I went from having no case to winning my case. And hopefully, you won't have all the problems I did because you're here attending today, and you will know ahead of time what to watch for and what to do. So, without any further ado, Mr. David Martin.
All right, good afternoon, and we'll start off talking about the tragedy that often occurs with ERISA cases. ERISA, of course, stands for the Employee Retirement Income Security Act of 1974. And go ahead and push that on to the next slide. And basically, that act guts state law and takes away a lot of the damages that you would like to have available in a case to pursue it. And that's caused quite a few problems. It originally started with a Studebaker plant going downhill and pensions not looking like they were going to be properly funded. And of course, back in the day, there were mobs and they would get control of pension funds, and there was a lot of problems. So Congress decided we're going to pass a statute that will take care of people's pensions. Very noble cause. And then at the last minute, after studying this for about 10 years, at the last minute, they decided to add in welfare benefits, which is short-term disability, long-term disability, life insurance, medical benefits, anything to do with the well-being of a person is a welfare benefit. And so ERISA has pension benefits on one hand and welfare benefits on the other hand. And they're treated a little bit differently, but suffice it to say that the welfare benefits didn't get as much thought as far as the protections needed as pension benefits did. In any event, fast forward now to the present day, and we'll talk about some of the issues that come up with ERISA cases that are problematic. ERISA is a very sneaky and deadly area of the law. The reason why it's deadly is because, as Michael pointed out, you can have a case that looks like a state law case, should be able to do this, and then the next thing you know, it's an ERISA case, and I have no idea what to do. And ERISA is a reticulated statute. That's what the courts call it, because it's like a python. You can't ever get a hold of the whole thing because it's always wrangling around in another place. So, you know, the point of that is that it's long, it's complicated, it's difficult to manage unless you do it all the time. It's not much fun. Now, it's not that it's rocket science where it's above your ability. It's just that it's really time consuming to get a hold of the statute, to understand it, to digest it, and then find out that there's, you know, 30 some odd years of case law. Well, actually 40, 50 some odd years of case law. It goes back to 1973 that you have to get into in order to really understand how did we get to this point and how does that help me in this case. And so as a result, it's not very cost effective for you to do ERISA unless that's just what you're going to do. And that's what our practice is geared towards, just doing ERISA. And so that helps. Now, the reason why ERISA is deadly to your case is because you will get your case dismissed. If you assert many state law claims and none of those claims matches up well with ERISA, then you can end up with a problem. You can end up with your case dismissed. The cases that it pops up in are personal injury. For example, you may have a liability limits auto accident case and you have $50,000 in medical bills, but only $25,000 in liability insurance to cover it. And the insurer says, yeah, we see our person was at fault. We'll go ahead and pay the policy limits. And you go to settle the case, and then you find out that the medical providers had their bills paid by an ERISA plan. And that ERISA plan then says, we want all our money back, every dime. And you say, wait, you know, I'll give you a pro rata share to get you taken care of, but you know, my person didn't get made whole. And the ERISA plan then says, it doesn't matter. Our plan says the make whole rule is abrogated in this instance, and the plan controls. And, you know, it may even say the common fund is abrogated. And so those default rules that might be in place in the typical personal injury case more or less gut the case. And now the attorney did all this work on a $25,000 case, and the client suffered all these injuries on a $25,000 case, only to have all of the money go to the ERISA plan. Not fair, but that's the hijacking that ERISA does. And then, of course, it can pop up in a domestic relations case where you have a simple divorce and somebody messes up and doesn't do a qualified domestic relations order, and years later there's a problem. Or it can pop up with whether you get medical care or not, whether medical care is reasonable and necessary. And there can be some real viciousness in that, where, you know, maybe you have cancer and you need this medical care, and the plan is saying, no, we're not going to pay for that. So there's a lot of areas that can pop up in, even bankruptcy, Social Security, workers' comp, and the list can go on. And so basically you just have to watch out for it and recognize that it's there and that it could destroy your case in particular. It can destroy your case by causing it to be dismissed because you didn't follow the claim remedies. For example, Walmart has had in the past a plan for their medical benefits where if you got hurt and you had a, say like in this case that was known as Shanks from the 8th Circuit, In that case, there was a horrible injury, quadriplegic result for the person, and $500,000 in medical bills. I'm just picking a number out of the air, and the liability insurance was only maybe $650,000 that would ultimately pay in damages on the case. Horrible injuries. Well, the Walmart plan required that you make a claim to reduce their subrogation interest. So they claimed they had the first right of every dollar out of that $650,000, and that they didn't have to pay any attorney's fees. The only way to get around that, they said, was this claim process where you had to make a claim to Walmart saying, hey, I need some make whole relief and some common fund relief to get a reasonable recovery here. And if you didn't follow that claim process, then your case could be dismissed, and you would suffer the harshness of the make whole rule and the common fund rule. There's no jury trial with ERISA cases. There are no extra contractual damages with ERISA cases. There are no punitive damages with ERISA cases. So there's a lot of ways that it can destroy your case. And here's why it destroys your case. The next slide will show these two worlds. One world is preemption world. The other is, well, the preemption world of ERISA, and the other world is state law. And those worlds do not mix. You don't have state law claims in any case that is preempted by ERISA. ERISA just takes over. And you might say, well, you know, there was really egregious conduct here. I should be able to sue under ERISA, but then also sue under state law to get some sort of mental anguish or punitive damages. Not allowed. The ERISA world is stronger and it controls. And then the next slide will show, you know, that there's a dilemma that most people have. How do you know if it's ERISA or state law? How do you know which way this goes? And generally speaking, ERISA is going to be involved in just about any benefit plan where you have an employer providing that benefit. So just assume it's ERISA if you have an employer provided benefit, whether that benefit's medical insurance, severance pay, a pension, life insurance, just about any of these things. The only clear exceptions that you can spot right out of the gate are payroll practices, where an employer's promise to give you a certain amount of sick pay may not likely be governed by ERISA if it's coming out of the employer's general assets. It's just an extension of your paycheck and you're not working, but there's this sick pay benefit or vacation pay benefit where you are actually getting paid still at the same rate of pay. So assume it's ERISA is usually the best strategy. Of the cases that get dismissed under ERISA, the greatest percentage of them is because the attorney did not recognize that ERISA was involved. So change your assumptions. Assume that it's ERISA until demonstrated otherwise. Now I got this slide about this bomb, the preemption bomb, and there's two kinds of preemption that can catch you with your case. There's the complete preemption. And complete preemption is where federal law completely supplants the area. And a good example is breach of contract. So perhaps a client has come to you with a life insurance case and they can't get anybody to take it because it only involves $15,000. A lot of money to that client, but maybe not to a lawyer who's in private practice. And so they come to you and they say, I want you to help me with this life insurance case. And it was a benefit provided by my employer. Okay, great. And so you go to file your lawsuit and you're going to file a breach of contract claim because the life insurance claim didn't get paid. That claim is completely preempted by ERISA. A benefits claim under ERISA is the equivalent of a breach of contract claim under state law. And so ERISA controls that claim entirely. And that state law breach of contract claim will serve as the basis for your case to be removed from state court to federal court because of complete preemption. The state law claim will be read as an ERISA benefit claim and it gets removed. And then the state court loses complete jurisdiction and control. Only the federal jurisdiction will control. And then the judge will likely dismiss the complaint unless you replete it to specifically allege that it's an ERISA claim. Then there's conflict preemption, and that's where maybe you sued for breach of contract, and you also sued for bad faith because this insurance company had no good reason to deny this claim. No legal or factual reason. And so that meets the elements of bad faith, and so I'm suing for bad faith too. But defensive preemption or conflict preemption will gut that case as well. It knocks it right down because once Congress gave specific remedies under ERISA, conflict preemption guts out everything else. So you have no relief under state law if the area is conflict preempted. So under a state law claim, we'll do a quick comparison of the damages available. Under a state law claim, you can have a jury trial for a breach of contract. Back one.
Yeah, I got it, yeah.
There you go. Okay. And then you can have damages that flow from the contract, consequential damages, and then you can also have mental anguish damages. And the mental anguish, of course, requires a pretty heavy burden to show that the contract concerns some issue of mental solicitude. Like a car warranty case, for some reason, the courts have said that might get to the mental anguish damages. Something that has to do with your home may well get to your mental anguish damages. And then, of course, if there's bad faith, you can seek punitive damages, and usually bad faith will have a claim with mental anguish attended with it. So that's what you can get under state law for a breach. But under ERISA, the damages are remarkably different. First of all, that slide shows there's no bad faith, there's no punitive damages, there's no mental anguish damages, there's no jury trial. All you have are your benefits. You just get your benefit, and the contract under ERISA could also have some onerous provisions in it that shortens your statute of limitation. Under state law, a breach of contract claim may allow a statute of limitations of 6 years. Under ERISA, it can be as short as 60 days. All right, so that's something that's real important to remember. Get the plan early if you have a case that arises out of any benefit from an employer, because you need to know if it has a very short limitation of action provision in it that in effect shortens your statute of limitations to that date. Most of the time, insurance policies governed through ERISA are going to have something along the line of 3 years from the date proof of loss was required to be furnished. And the Supreme Court of the United States has enforced those. You could have a venue provision to where your lawsuit may have to be filed, for example, in the state of Missouri, even though the employer's in Alabama. You may have a choice of law provision in there as to the law that gets imported into ERISA. ERISA is a reticulated statute. It has a lot of details with it, but sometimes it imports state law where ERISA is silent. And so that can get imported in as a particular state's law. And then you also need to look at whether the make whole relief disclaimers in the plan and the common fund disclaimer. So again, ERISA can destroy your case. It's important to recognize the danger that it poses. If there's no qualified domestic relations order in a domestic proceeding, you messed up. That spouse may not get the pension at all if left out. That qualified domestic relations order has to go to the plan administrator. If you're in an accident case and you see there's low liability limits on the case, you better get the ERISA plan right away before you invest a bunch of time and money on that case, because you could be wasting your time and money. The whole case may actually belong to some ERISA insurer or plan administrator. So you want the plan early or that case could get destroyed. Same thing with a life insurance case. Then there are these cases that occasionally pop up that are absolutely incredible. And that is where the employer deducts money from the employee's paycheck. And that money is supposed to be sent to the insurer. But instead of sending that money in, the employer keeps it. So the employee then is making less money by paying for a benefit where there's no benefit coming in return. the benefit is going to lapse. There's going to be no coverage. The employee may not even know there's no coverage. And so those cases are really bad, and sometimes they only involve a little bit of money, maybe say $1,500 or $2,000 after a year of deductions. So what do you do about that? Well, if ERISA preempts it, you're in a bad shape. You don't get punitive damages under ERISA. You don't get mental anguish damages. You could have a cancer diagnosis and need this health plan to cover that treatment, and now you find you have nothing. That's a tough position to be in, and that happens. And it can happen very easily because employers have QuickBooks and other payroll systems where they automatically make these deductions, and then they look how much money is left when they go to pay the bills at the end of the month, and they're not segregating those funds, and so then they say, well, we're going to have to skip paying for that insurance because we don't have enough money to cover it. Well, that's not good, and that should not occur. The relief in that situation is difficult to obtain. The relief is to either get your premiums back or to make the employer personally responsible for the insurance coverage that should be in place. That can be difficult though, because by that point in time, the employee already didn't get the treatment, because a lot of medical providers are not going to treat you if you don't have your money up front or you have insurance. So it's a rather unfair situation that can develop, but that happens.
And we do have one question. It goes back to something you had mentioned a little bit earlier. Somebody asked, they said you mentioned a 60-day, that you might have to do something within 60 days, but then sometimes within 3 years. What types of things would you have to do within 60 days or very short periods of time that ERISA plans might require, like in very short periods of time, that they should know about?
Well, with ERISA plans, there are deadline intensive cases. Okay, first of all, let's just say that. All right, they're very deadline intensive, and if deadlines stress you out, I'm sorry. They're very deadline intensive. So the claim process is going to have deadlines. But what I was referring to with the 60-day time limit and the 3-year time limit was the time to file a lawsuit. And you better file a lawsuit that's accurately pled, because if you file a lawsuit asserting nothing but state law claims and your case gets dismissed and then you refile it, it might not necessarily relate back, and then you will have blown the statute of limitations in the ERISA plan. So there's some bad traps for the unwary. And so that's why I'm going to give you some information as to what to do after I've underscored the danger that is there. I'm trying to convince you that there can be a lot of dangers in ERISA cases, and once you're convinced of that, then we'll show you what you can do about that. The next slide is what can you do to spot trouble? Okay. Well, number one, of course, is to change your assumptions. Assuming that a benefit through the workplace is not ERISA governed is a bad assumption. So first, assume ERISA applies until shown otherwise. It's kind of like saying that somebody is guilty of a crime until proven innocent. It's just the opposite of what you would intuitively want to go with. State law is not the catch-all here. ERISA is more likely the catch-all, and the exceptions will be state law if it's a work-provided benefit. It can also be an association-provided benefit, so you have to watch out for those. For example, the teachers in our state, some of them are hired directly by school boards. Some of them receive a benefit, though, not through the school board, but they receive a benefit through an association, the Teachers Association. And so it can be ERISA governed through an association or through an employer. Second, keep a database of cases and situations handy. And then third, ask an attorney that regularly does ERISA for some help. Don't be bashful about it. I answer emails with people. I'll talk to people. You know, there's a lot of ERISA problems out there, and some of them are difficult to handle. And so ask. Don't be ashamed of it. In that first part about changing your assumptions, it also helps to understand the ERISA process. Okay, so if you're going to change your assumptions and assume it's ERISA, what you're also assuming about ERISA is that you have to follow the ERISA process. So the ERISA process works like this. First, you make a claim. Then there's a denial. At that point, you can ask for the claim record and all the information upon which that denial is based. And then you can also ask for the plan documents at any point in time. But you certainly want to get that claim record. Then after you go over the claim record, then you can make an appeal. And then if your appeal is denied, again, you have an opportunity to get the claim records. And then so after you get the claim record that second time, you look at it and you look at the plan, and the plan could require a second appeal. So then you make another appeal. At that point in time, going through at least 2 appeals like that, you have exhausted the claim process. You've done everything you can do through the plan process to take care of that claim. At that point, then your time limits for filing a lawsuit are real critical, and you need to file a lawsuit within those time limits. Then you file a lawsuit. Once you're in litigation, though, the court is only going to look at the bucket of information that was in the claims administrator's or plan administrator's possession. All right. So that's why when you make your claim and it gets denied, you want to get the claim record, but then you want to submit as much information as possible to counter the reasons why they denied that claim. You have to do more than just barely beat the reasons why the claim was denied. You have to thrash them. You have to destroy all of the reasons why the claim was denied. Just 51% is not enough. It's more like proving beyond a reasonable doubt that they committed a crime, okay? That's what you're going for. Just, you know, eviscerating every reason why they denied that claim. And then after you get that information back and make your presentation, if they still deny the claim, they may have shifted those reasons. So you get the claim record again, and then again, you would try to eviscerate those reasons. All that information through that claim process is put into the bucket, and then the court is going to look in the bucket as to what was the claim decision, and does it agree with the claim decision? If it doesn't agree with the claim decision, was the claim decision unreasonable? And so that gets into the standard of review and so forth, which I won't get into today, but nonetheless, that's the process that you go through. You have to assume that there's not going to be much discovery in federal court, and that you're entirely dependent on the information that you presented during the claim process to win your case. All right. So it's just the opposite. With most cases, we feel like we've got to engage in discovery and work the case up. And that's when you do your heavy lifting, is during litigation. With ERISA, you do a lot of your heavy lifting before you get to litigation. All right. Now, are there some ways to get around ERISA? There are 2 ways to get around ERISA. Well, there's actually 4, but we'll go with these 2 for right now. The 2 initial ways are to get into one of the safe harbors. I like that word because ERISA seems like it's a storm all around your case. And so if you can get your case into a safe harbor, then you can go back to what you're more familiar with and work on a state law case or claim. The first harbor is the harbor I call the J harbor. And so there's this regulation 29 CFR 2510.3-1J. And the J harbor is where an employer provides a benefit through the workplace, but the employer is not making any contribution. It's voluntary for the employees to sign up. The employer just collects premiums and remits that money to the insurance company. And then there's no consideration given to the employer for doing any of those services. So a good example of that would be Aflac. Maybe you've seen the recent Nick Saban commercial in a blue jacket, and he's selling Aflac insurance to these people. Well, Aflac will sell insurance in your private home like that, but they also will go to the workplace and they'll sell this supplemental or gap insurance to people in the workplace. And that is generally not governed by ERISA because it meets those 4 criteria. So if your case meets all 4 criteria, you're into the safe harbor. A lot of federal judges will let that case get removed from state court to federal court And then you're gonna have to know how to get it back to state court by showing those 4 elements. And it might take a bit. You might have to actually engage in some discovery to find out whether these elements are met, because your client probably doesn't know. They may know it's voluntary, not everybody signed up, but you've got to have all 4 elements met here in order to meet that safe harbor. The next slide is the second safe harbor, which I call the B harbor, and that's what I mentioned earlier. That's a payroll practice. That's where maybe the person is getting short-term disability and it's really like sick pay. And it comes out of the employer's general assets. The person's getting their normal compensation. If they're making $15 an hour when they're working, then after they're sick and not able to work, they still get their $15 an hour. And usually you have to be unable to work due to injury, illness, or pregnancy. So there's 2 ways. The other 2 ways to get out of ERISA are if you were with the government. Isn't that nice? Everybody else, ERISA applies to you. Government employees, no, it doesn't apply to you. So that's one way to get out of ERISA, is to have a government provided benefit. And then the other way is a church provided benefit. Now, churches can opt back into ERISA, but the default is that a church plan is not governed by ERISA. So, for example, there's Catholic hospitals in Alabama, there's Baptist hospitals in Alabama. A lot of times those benefits are going to be exempt from ERISA. Now, UAB has gained control of some of the Baptist Health System's hospitals. And so then there was a question as to whether that majority ownership by UAB constituted a government plan, but it's not. It falls under ERISA because majority ownership isn't enough to make it a government plan, and it's no longer, it's still called Baptist, but it's no longer run by a church per se. Now let's move on to the weapons, okay? So this is where the rubber meets the road. This is the part where you really got to understand, what do I do here? So I get the dangers of ERISA. I understand those exceptions to get this out of ERISA. So that's good. But what if you don't meet any of those exceptions? Then what can you do to just straight up fight? And first of all, the employer has an obligation to provide plan documents. And I say employer, it could be the plan administrator, okay? The technical term under ERISA is plan administrator, but the plan administrator is whoever is listed in the plan document as being the plan administrator. And if it's not listed, then it's the plan sponsor. And if the plan sponsor is not listed, it's the employer. So that's why I said employer. Person coming to you is not going to know the answer to that question. Who is the plan administrator for your benefit? Well, I don't know. I don't even know what a plan administrator is the typical response. So you want to ask for a request of all of the documents from the employer's HR department, from the insurance company involved with the benefit, and anybody else you can think of. One of them most likely is the plan administrator. So you don't just send one letter out, you're going to send the same letter out to 3 or 4 different people. That request for the plan document needs to be in writing. It needs to be either from the participant, or it needs to be crystal clear that you're acting on behalf of the participant. And you need to ask for the policy, the main plan document, the summary plan description, all of those documents, because that's your rule book. And if you want to know how to fight, you need to know the rules first, okay? Second, you need to ask for the claim manual. The plan administrator is also obligated to provide the claim manual. And the claim manual is the more fine detail of what the plan document says. Sort of like a corporation or a LLC having a main document, like for an LLC, a certificate of formation or articles of formation or incorporation or whatever, and then there's bylaws. So the claim manual is like the bylaws. Excuse me. And so you want that document as well. That's their playbook. Those two documents right there are their playbook. And if they did something inconsistent with those two documents, then they have a problem. And so now you get to go on the offensive by getting their playbook, knowing how they're supposed to be playing, and then looking for ways where they did not play right. They did not play fair. And then the last thing is you get the claim record. Now this is an advantage over state law claims, because insurance companies, before you get into litigation, most of the time are not going to give you their claim manual, and they're not going to give you their claim record. All right? Under ERISA, they have to give you those. And if they don't give you the plan document, that can give rise to a statutory penalty claim. We'll discuss more later. And if they don't give you the claim manual, then there's a dispute in the law right now, but the Department of Labor says that also is a plan document, and they have to give that to you or they can be subject to a penalty. And then last, the claim record lets you see the details as to what is in the claim record, what more needs to go in the claim record, and why they really deny the claim. A lot of times the letters denying a claim look like boilerplate. You know, we don't think you're disabled because you don't meet the definition of disability. Well, that's real helpful. Thanks. Appreciate that. Yeah. So you have to actually get the claim record to see all the details, and you have to go through it with a fine-tooth comb and really study that claim record. That's where that process I mentioned, where you file a claim, it's denied, you get the claim record, you make another submission and you appeal it. And then if the appeal is denied, you got to look and see if you have to do a second appeal. That engaging process going back and forth underscores why it's so important to get that claim record. If you file your lawsuit and then you get your claim record, you're fighting with both hands tied behind your back. All right, you're going to get beat up. You want that claim record before you file a lawsuit, and they have to give it to you. If they don't, then the regulation says that claim is deemed exhausted, and you're allowed to take the case into court, and you may get a better standard of review when you go into court than you would otherwise. All right, next, know your reward. Know what damages you can get out of ERISA. So we're going to go to fighting with ERISA. We're going to get the plan document. We're going to get the claim manual, and we're going to get the claim record. Now, let's say they don't give you the claim manual and they won't give you the plan document. All right. And you asked for that from the employer, from the insurance company, and from a third-party vendor. And none of them would give you these. Okay. Well, first of all, the very bottom part on that slide there says penalties. So if they don't give you the plan document within 30 days, your client has a right to sue for statutory penalties of up to $110 per day. Well, if that rocks on for 6 months, that creates some good leverage for your client. That creates a pot of money for your client. Now, it's up to a federal district court judge to award those penalties, but nonetheless, it's there. And if you have asked for a plan document and then you have this subrogation lien on this auto accident case over here, and 6 months, 9 months, a year goes by and you still don't have the plan document, you made your proper request. Well, now you have some leverage to push back against them regarding that subrogation claim. So penalties are a very useful tool to assert damages against a plan administrator. ERISA will allow you it will allow you a benefit claim, which is your breach of contract damages in essence, without any extra contractual damages associated with it. So the benefits are the actual amount that you should get, and then you drop down a little bit there, and you may also be able to get interest. Now, right now in Alabama, that's a big deal because some federal courts have awarded interest at the rate of 1.5% per month. That's 18%. You can't get that investment rate anywhere. So your benefits claim all of a sudden might have a bit more value if you assert that right to interest with it. You still don't get mental anguish. You still aren't going to reach bad faith, but that's okay. You at least get that. Then there's equitable relief or make whole relief, putting you back in the position you should have been in. Now, you don't get equitable relief and benefits out of the same facts. You have to take one or the other depending on what your facts are. And so equitable relief, the Supreme Court has said, is more like a catch-all. So if you can't get benefits, then equitable relief is what you're after. And let me give you an example of that. There's this case called Jones, 11th Circuit case. And in that case, these employees were supposed to get a certain welfare benefit. All right. And they didn't get that benefit, so they also sued for equitable relief. And they didn't know how the litigation was going to turn out, so they sued for benefits and they sued for equitable relief. And in that case, it was determined that they had no right to benefits. The employer messed something up, gave false information out, they relied on it, but there was no benefit, contractually speaking, in place. But nonetheless, because they had relied on the lies or misrepresentations from the employer, that gave rise to equitable relief, where they may be able to nonetheless get the benefit they should get for having relied upon that, but it's going to come from the employer's general assets rather than from this benefit plan asset. So that's equitable relief, putting you back in the position to make you whole. Then sometimes there are these cases where there's exorbitant fees on a 401k plan, or they really mismanaged the pension assets and they caused a decline in a benefit. All right, that's this fixed, imprudent, self-serving investment decisions. And we see that occasionally, where the Board of Trustees for a pension plan enjoys a vacation at Lake Tahoe while they have their 1-hour board meetings. Week-long vacation, 1-hour board meeting, not a bad gig. And if it's causing a depletion in plan assets, and they do that for years straight, and then all of a sudden now there's not enough pension money to pay these pensioners, something's got to give there. And so that's when you may be able to get relief for self-serving and imprudent investment decisions, which is what they're supposed to be doing. It's supposed to be following the prudent person rule. And then, of course, the two good parts of ERISA are the fact that you can assert a claim for attorney's fees, and that is keeping track of your time down to 6-minute increments as if you're working by the hour. And you can assert that claim for attorney's fees in federal court. And if the court finds that the elements for a fee award are met, then the court may well award you attorney's fees for all your time incurred on that case. And then there are statutory penalties. Now, let me give you an example of when attorney's fees might help. For example, in that matter I mentioned to you where they took an employee's money out of her paycheck, deductions, didn't send it into the insurance company, but there's only $1,500 or $2,000 to get. Okay, well, you sue to get that money back, the premiums back, or you sue for equitable relief to make the employer pay for the treatment that's needed, if that's possible. But you can also sue for attorney's fees. And if you end up putting 200 hours in that case, your client may only see, $1,500 or $2,000 in damages getting their relief back, but there may be attorney's fees at stake for $80,000, $90,000, $100,000. And so that sort of turns the tables a bit to where ERISA is now being used as a sword in your favor rather than always being a shield against you.
We did have one question, and
Sure.
it was, you mentioned that when you ask for the plan documents, you may send the request to several different places. Is there a method that you, is it always certified mail, or do you do anything to document it so that you later can prove you requested them?
It's a very good practice. If you have a fax number, send it via facsimile, so at least you have a fax confirmation page to show for. Sending certified mail is a better practice, because then you have at least a green card, as long as the post office does it right. You have a green card demonstrating receipt of that. But those are the kind of games that can get played with that. And so that's a very good question. You want to make certain that you can show a participant made that request, or a lawyer acting on behalf of a participant, and it went to the plan administrator and they got it. Because a lot of times they'll say, oh, we never got that. So good question. Any other questions on that issue?
Now, there's one question about I went to the end because it's kind of a long fact scenario.
Okay, all right. Okay, well, on the statutory penalties, that the slide just happens to come back up on this. You got to make sure you do get it to the plan administrator, which is why I said send it to multiple places so that you do have a solid penalty award. There are case after case after case out there of people making a request on the insurance company, and see the plan says the employer is the plan administrator, the insurance company is the funder of the plan, so the insurance company is a mere claims administrator. And the courts have not stretched that penalty relief in most instances to that claims administrator. Well, in the 11th Circuit, we have a way to reach that claims administrator, and it's the de facto rule. But there are recent cases where the courts will not extend that de facto plan administrator rule to the claims administrator. And so we have to watch out for that. So you make your request on multiple entities. What happens a lot of times is an employer is the listed plan administrator, knows nothing and does nothing about the case, but they do have the obligations. And the claims administrator over here, say, is life insurance company in North America, Cigna company. All right. They're making all the decisions. They're denying the claim. They have the claim record. They gave you the claim record. Maybe even they gave you a claim manual, but they're refusing to give you the plan document. Okay. And so now it comes time to file a lawsuit. That puts the participant in the position of having to sue their employer to get the statutory penalty claim and suing Cigna or Lena for the benefit. And so it creates some strange bedfellows in litigation when that occurs, but that's how the courts are cutting it. The plan administrator is who is listed in the plan document. De facto administrator works in some instances where there's somebody that has assumed all control, and in that case, you can sue that entity who is actually assuming all control. But Cigna will always say, well, we never had the obligation to give out the plan documents, and that always rested with the employer, and so if they didn't do their job, that's their problem. And so that's what Cigna is going to say in that situation. Anyway, so the penalties are important to get set up correctly. This kind of catalogs then, again, what we've gone over here on what you need to do to break free of an ERISA attack or to win it, and that is make a written request for the plan and the summary. You want both of them, okay? Now there's a little wrinkle there as to why you want both the summary plan description and the plan document. The ERISA statute says the employer is supposed to automatically give the summary plan description to all employees, okay? Well, the summary plan description is supposed to be just a summary, but sometimes it says stuff in it that is not in the plan document. So you want both the plan document and the summary, because then you want to compare them. You want to know what were the employees told would be provided to them, and what does the plan document actually provide? Because what's supposed to be controlling is the main plan document, all right? So if there's something in the summary that's not in the plan document and it's helpful to your client, well, then you want to be able to argue that. And if there's something disadvantageous in the summary that is not in the plan document, you want to be able to argue that. So that's why you want both of them. And it's important to get both and to request both. And they're supposed to give it to you within 30 days. Then you also want to request the claim manual. Sometimes there are certain drugs and medications that are just simply not on their list. And because it's not on our list, we're not going to say it's reasonable and necessary for you. So you need that document, because the plan document is not going to help you fight that ERISA case. So you've got to make that written request, and then you want to request the claim record, which is kind of weird when you're doing an auto accident case, and then you want the claim record on all of these claims they contend that they paid. Well, that's necessary because they may be saying you owe us $50,000 in medical payments when you get your settlement out of that personal injury case. Okay, Well, let's look. Are all of those medical payments that you made related back to the same injury from that personal injury case? If they're not all related, then why am I paying back just general money going back to the insurance company? That's not right. All of those injuries need to relate back to the same set of injuries over here. Otherwise, you're getting a recovery for things that don't have anything to do with our recovery. Hope that makes sense. And then, of course, that claim record will allow you to evaluate how they paid the claim, why they paid the claim, and what's going on with it. And if they don't give it to you, that can create problems for them. And then after you get their claim record and you see what gaps there are in the proof, because again, your challenge is to eviscerate every reason why they have denied the claim or every reason why they're a problem in your case. And so you get that claim record, you go through it, and what else can you put into the claim record? The strategy in ERISA cases is jam the record. For the plaintiff, you want to jam the record. You put everything and anything relevant to your case and that's beneficial to your case into that claim record, because that's what the judge is going to review. So if you got this really great expert report that you want to use in litigation, but it's not in the claim record, too bad. You're not likely to get it because that information wasn't in front of the insurer. That means that you're getting expert reports before you even file a lawsuit. You're getting a report from a treating physician before you even file a lawsuit. Maybe they've got a doctor over here in their claim record that says, you know, this lady's diabetic condition has no effect on any restrictions and limitations. And so you see that report and you say, that's not true. And so you go back to the treating doctor and the doctor looks at the report and is able to point out specific instances in the medical records that show that doctor's report in the insurance company's file is absolutely wrong. That's what you do with ERISA, okay? You get into the details before you file a lawsuit and you take away every reason they have to deny that claim. Okay,
Well, how often, when you're doing that process, are there ever instances where when you put a lot of work into the claim process that they then change their minds and grant the claim?
They do.
Yeah, really.
Yeah, and that's good, but you don't get attorney's fees then. Because anything pre-litigation and that's related to the claim process is not compensable under the ERISA statute. So your client can't be made whole if the claim process works and they do get what they're supposed to get. And so that's the unfairness in ERISA. You know, if at the same time, you can't sandbag and say, well, I want to push this into litigation so I can get attorney's fees, because the court's going to look at your bucket, the claim record. As a matter of fact, the courts call it the administrative record, which dignifies that claim record from the insurance company to the same kind of status as the Social Security administrative record or some government agency record, okay? Well, Social Security has a lot of administrative rules, volumes of rules that all of their people have to go by. And you don't have those volumes of rules and due process rights attended with the administrative process in an ERISA case. So that's why I call it the claim process, because I don't like to dignify it as if it has the same due process guarantees that you would find in an administrative record. But nonetheless, that's the language you see in court opinions, the administrative process. And if you don't go through that administrative process, your case will be dismissed for failure to exhaust claim remedies. Okay? All right, there is one example of clever lawyering that I wanted to bring to your attention, where somebody was able to get a case out from ERISA. And this could happen lots of different times. Man was involved in an automobile accident, severely hurt, and this was called the Hendricks case, by the way, and Judge Bowdery had it in the Northern District of Alabama. Site, I believe, is in your materials. And so he horribly injured, and so he has all this medical care and medical treatment and so forth. And then the medical provider, which was a United Group plan, and medical provider did not want to continue to pay for in-hospital therapy and care. And so the man had to be discharged from the hospital. And United said, we're just going to pay for a nurse to stop by once a day and check on him. Well, that wasn't enough, and the man died. So then his heirs filed a lawsuit. And of course, United said, ERISA, this is ERISA, and removed it to federal court. And Judge Boundary carefully looked at it and said, well, the heirs are bringing a wrongful death case under state law. And that's purely a punitive damages case. And so there's no benefit recovery being sought by the heirs here. What they're seeking are punitive damages based on the wrongfulness of the conduct of forcing the man not to get the medical care he needed. And so Judge Boundary said that's non-ERISA. I put a lot of those facts in a footnote in the material, so you may want to look at it, but good lawyering like that can also be another way of getting around ERISA. So that's everything I wanted to try to get through in this material. I think there was a question that you had.
There's a, let me pull it up. I'm just going to read it because I don't want to try to cover it and not be sure I'm getting it right. Under the beneficiary of life insurance in divorce and in case of remarriage. So if there's no valid current spousal waiver, is there a provision that someone other than the current spouse can receive the proceeds, such as a child from the previous marriage? And I guess the question is, it involves like getting remarried, and is that going to be covered by particular ERISA plans?
Okay. Yeah, I have a case like that right now, and so they go both ways. But let me tell you the analysis step by step. Okay. First of all, the plan document controls, and so the participant in the life insurance plan dies, then somebody is going to make a claim for that benefit. All right. And so the plan is going to look at who is the designated beneficiary. And if there is no designated beneficiary, then the plan looks at what happens when there's no designated beneficiary. And if the plan then says it goes to the estate or next of kin, then that's where the money goes. That would be the next step. So the plan is going to control on who can assert that beneficiary claim in that situation. And sometimes lots of people are asserting it from different angles. The thing that gives you an advantage in that situation is if your client makes that beneficiary claim and nobody else does, then the others can be said to have failed to exhaust that claim process. And so your client may have preferred rights in that situation because they followed the rules and went through the process. So you definitely want to get the benefit plan and then look at it. The Supreme Court of the United States in the DuPont case has said, whatever's in the plan document and whatever form was filled out listing the beneficiary, that's what's going to control. And that's where it can bite in a domestic relations situation. Because if the plan document says spouse A was the beneficiary, but then that person is divorced, and then spouse B is now married to this person who dies, spouse A is still listed as a beneficiary, and that's who the payment will be made to. Wow. There's a state law that says in the event that your life insurance plan is in effect before the divorce and after the divorce, then whatever beneficiary you named before the divorce is no longer valid. There's a state law that says that, but I don't think that's going to change anything with the plan administrator's decision. The plan administrator, according to the United States Supreme Court, gets to go by what beneficiary designation is in that plan document, and that's how the payment will be made. Now, if there's some other grounds for the subsequent spouse to sue that first spouse to get the money, then, you know, if it's not ERISA, that's a state law matter. And so you may have some argument there. I hope that's clear enough.
Yeah. Well, I guess the only hope there was maybe if it's not an employer provided life insurance, because it sounds like if it is.
If it's not employer provided, then you have a state statute that helps you in that circumstance. Or if you can get it out of ERISA. You also need to look at the controlling law in the plan document, because if the controlling law is from another jurisdiction, then there's a whole analysis that you have to go through for that.
He said, thanks for the answer. Yes, it's an ERISA plan. So we got about 2 minutes left. And the only question I have left, this wasn't one of theirs. Are ERISA plans ever found unconscionable? Are they ever so unreasonable that they won't be enforced by the courts? Or is that really unusual?
That's very unusual. What a lot of plans do is make certain that they pay some sort of minimal benefit so that you're still getting something for the premium that you paid. Give you an example. This happens frequently to Walmart employees. They're only making maybe 10 or 12 bucks an hour, and they have a long-term disability benefit that's supposed to pay 50% of their wage. And then it also has an offset for Social Security benefits, and then also dependent Social Security benefits. And so the person gets, you know, they're supposed to get a benefit of, say, $1,000 a month, and then they get Social Security, and their Social Security and the kid's Social Security is $1,300 a month. That's more than the long-term disability benefit. So with the offset, you get zero. You get nothing. You went in reverse. You're minus 300 there. So then the benefit may actually pay, the plan may actually pay like a $50 benefit or a $100 benefit to keep it from being illusory. Well, you can't even pay a light bill with 50 bucks anymore. So it still is illusory in my view, but nonetheless, those are some of the kind of plans that are out there. If you want a little booklet, I've got a booklet I give to lawyers for free. You can go to my website. It's www.erisacase.com. It's on the materials. Go to the website, and I have an attorney's page, and you can ask for a free booklet. It's a free e-booklet. It tells about the dangers in these disability plans, and you can use that in your analysis in the future, or even in looking at your own disability plan or the plan of your employer, to make sure that everybody's aware of the unfair provisions, and then maybe you want to shop a little bit to get a better plan.
Oh, I want to stress that Legal Service Alabama's plan is obviously very fair to all of our employees who may be attending right now. With that being said, we are at 1 o'clock, and so I appreciate you coming, Mr. Martin, and thank you for talking to us. And hopefully now we don't make the same mistakes I made several years ago and don't need to call you for a lifeline. So thank you so much.
Thank you.
1 second.